Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado bankruptcy and student loan relief attorney, and this is part 2 of my discussion about the Navient private student loan settlement. So in the description, I will link part 1, where I discuss who qualifies for private student loan forgiveness under the recently announced Navient settlement. But as you might imagine, a lot of people have a lot of questions about who qualifies, are they going to get qualified, and what are sort of the intricacies of how one qualifies to get the forgiveness offered under this settlement. So I'm going to address some of the more frequently asked questions that I've been seeing and that I've been fielding on this settlement. So to begin, I think it goes without saying, is first, the forgiveness is only going to be for private student loans. So if you have federal student loans, they're not going to be forgiven. Now, you might get a check for $260 or so if you were put in forbearance instead of offered something else for your federal student loans, but your federal student loans are not going to get forgiven. If you don't know if you have federal student loans, you can go to studentaid.gov. That's the Department of Education website for student loans. If you haven't already registered with that website, do so, and then you can get an inventory of your federal student loans. I think what's causing a lot of confusion here is that Navient is getting out of the business of servicing federal student loans and is transferring their federal student loan portfolio to Aid Vantage. So a lot of borrowers have gotten notices recently saying, hey, your loans are going over to Aid Vantage in a couple weeks or whatever, and understand that those are your federal student loans that are being transferred, and those loans are not going to be forgiven under this settlement. Second is so it's only for private student loans, but it's only for private student loans that were lent by or originated by Navient or its predecessor, Sallie Mae, which is the big one, or any of Sallie Mae's, at the time, subsidiaries. But basically, we're talking Sallie Mae loans. So if you have private student loans from another company that is not a subsidiary of Sallie Mae, you're not going to get forgiveness. Sorry. Excuse me. Okay, now one of the more confusing aspects of this settlement, or I think what's causing creating a lot of questions, is this charge-off requirement. So the settlement actually says that in order to qualify for forgiveness, the loans have to be in charge-off status. Now, it does define what that means. Charge-off means that the loan has not been, or has delinquent payments for 8 billing cycles or 212 days. And that charge-off status must have occurred within 7 years of June 30th, 2021, or within your state's statute of limitations to sue if it's longer than 7 years. Now, of the 38 states, there's not too many that have a statute of limitations longer than 7 years, so probably not something you need to worry about. However, there's a 7-year window that starts from July 30th, 2021 and runs backwards for 7 years. Your private student loans must have hit charge-off status during that period if they were charged off before. So this would be before June 30th, 2014, then your loans are not going to qualify for this forgiveness. Now, I think where things are getting possibly sneaky here, and where I think the attorney generals need to talk to someone, or people need to write their attorney general, is a lot of people had their private student loans put into some sort of voluntary forbearance, right? So if you called your Navient and said, hey, I'm having trouble paying my loans, they may have just put you into forbearance. All right, now, forbear payments are not delinquent payments. So you may have gone 8 months, 9 months, a year without making payments, but you were in a voluntary forbearance program with Navient, and those payments are not delinquent. And so the loan was never charged off. And so if the loan was never charged off, you're not going to qualify for this forgiveness. And I think this is a big oversight in this settlement, and is going to cause a lot of confusion with a lot of people, because a lot of people are saying, hey, well, yeah, I haven't made my payments for years. But there's a possibility you might have been in some sort of forbearance with Navient, and therefore those payments are not delinquent. The settlement agreement is not very well defined on this issue. Now, I think potentially good news is that the settlement agreement has yet to be approved by the court, so there may still be some time for this issue to get clarified. But at least under my reading of the agreement and the terms that they're using in the definitions, charge-off status means 8 delinquent payments and not just 8 not making payments. So they actually has to be past due in a delinquent or default status, and that status had to have occurred within that 7-year window from basically June 30th, 2014 to June 30th, 2021. Next, what if your loans have already gone to judgment? So let's say, because you can get sued for private student loans, so if you've already been sued for your private student loans and gone to judgment, what about that? The settlement agreement makes no specific reference to or mentions even student loans that have gone to judgment. So I think the default rule here would still apply. So as long as the loans went into charge-off status within that 7-year window, and of course that you're in the other 3 categories that I'll mention here in a second, it would still qualify. However, if the charge-off status predates the 7-year window, then whether it's judgment or not, there's going to be no relief. All right, but there's no special reference to judgments in the settlement, so you would just default to the rules, and you'd have to look to when your loan's charged off. I suspect, however, that if your loans have already gone to judgment, that the charge-off status probably occurred before the 7-year window here for forgiveness. Another interesting question here: what if you refinanced your private student loans? That's a tough one. I think you're most likely out of luck that you're not going to get forgiveness because you've created a new loan, right? So if you had student loans, private student loans that would otherwise have qualified for this forgiveness, but let's say a few years ago you refinanced them, not going to apply. And I think as a practical matter too, if you refinance them, you probably weren't in delinquent status anyway, because you wouldn't have qualified to refinance. So I think for most people this is not a real issue, because if you had the ability to refinance your loans, you weren't going to be in a delinquent status to do that, because most refinance companies are not going to refi delinquent student loans. But if you did, let's just hypothetically, if you refinance your loans, say you had a bunch of Sallie Mae loans and you refinance with SoFi, now you have these SoFi loans, you're not going to qualify. I think maybe the only carve-out might be, and it's an arguable point, is if you refied with Sallie Mae somewhere along the line. So let's say you had a bunch of older loans that go back to the early 2000s or whatever, and you refinance for Sallie Mae those loans that would qualify, and then went delinquent, maybe you qualify. But again, the settlement agreement doesn't specifically reference any sort of refinance, so I think refinance. So it's an arguable point, but I think the only people who might even have an argument would be if you refinanced with Sallie Mae, or consolidated your loans, or refinanced your private student loans with Sallie Mae, and then defaulted on those loans. You might still qualify at that point. Here's another more of a practical question. What if your private student loans are no longer serviced by Navient? Well, here the settlement agreement actually has a provision saying that Navient is going to will reach out to whoever is servicing your qualified private student loans to try to get them and try to get you the forgiveness. So, but you should still be proactive in trying to figure out if your loans qualify, and then get in touch with whoever's servicing them now and making sure this happens. But there is a provision in the settlement agreement about loans no longer serviced by Navient that would qualify for this forgiveness. Okay, then we have the 3 categories of loans. So again, the main qualifying factor is that the loans had to have been originated after 2002. And the charge-off date, or the charge-off, must have occurred within the 7 years before June 30th, 2021. So that's the 2 primary classifications or requirements for private student loans. And then you have to fit into one of three categories. So let me be clear about that. You only have to make one of the three different categories. It doesn't have to be all three or two of the three or anything like that. So the three categories briefly are that you either had a Sallie Mae opportunity or recourse program loan. So those are just specific loan programs that Sallie Mae had at the time. The second criteria is, which is probably the big one, for most people, is you attended some specific schools, and there is a list in the settlement agreement, and I'll post that list in the description below. But again, that's ITT Tech, DeVry, the Art Institutes, Education Management Corporation, Globe, Graham Holdings, Infinolaw, Lincoln Tech. So there's a whole bunch of technical schools that fall into these categories. And then the third one is what they call non-traditional loans. And this one's a little confusing because non-traditional loans isn't really a thing necessarily. They just define it as you received a private student loan from Sallie Mae, again, dispersed after 2002, but your FICO score was below 670 if you attended a for-profit school or below 640 if you attended a nonprofit post-secondary school. What I think they're getting at here, although they're using the term non-traditional, is what I refer to as either conforming or non-conforming private student loans. Because these non-traditional loans are probably loans that were given outside of the financial aid office of the school you attended. So all schools have what they call cost of attendance. And this is the estimated cost of attendance that takes into account tuition, fees, costs of living, and that sets a cap on how much you can borrow in total, and that cap applies to federal student loans and conforming private student loans, right? So the school won't let you borrow more than that. However, non-conforming private student loans exist outside of that cost of attendance cap. And so you can go out and borrow directly from Sallie Mae or from a bank and get a non-conforming private student loan to borrow additional money beyond the school's estimated cost of attendance. So for example, just real quick, so let's say the cost of attendance is $100,000 and you get a basket of federal student loans and some private student loans up to that $100,000 mark, and then you still want to borrow more on top of that. Now, why would you? I don't know, but let's say you do. Then you can get a non-conforming private student loan, and I think that's what they're talking about here with these non-traditional loans, because again, these are basically regular loans. They're going to have a creditworthiness requirement, and so they're looking at the predatory aspect of these student loans, and people with really bad credit really shouldn't have been offered these non-traditional or non-conforming private student loans. And so, but that applies to whether you attended one of these private student or one of these for-profit schools or a regular college, for that matter, if you got some additional private student loans. So anyway, so those are some of the more frequently asked questions. Feel free to post questions in the comments. Obviously, I can't give you specific legal advice on your situation. However, I do offer phone consultations to residents of Colorado and to anyone with student loans. Student loan consultations do cost $169 to discuss your situation. However, most of the time I can get you the information you're looking for, get you pointed in the right direction, and you probably won't need to hire my services. However, if your situation is more complex, we may be able to offer you our services, and we would certainly discuss that. Again, my name is Matt Burkus. I'm a Colorado-based bankruptcy and student loan relief attorney. Best of luck to you.